Hi, everybody. My name is Daryl Cartwright. I'm an attorney in Birmingham, Alabama, and I practice throughout the state of Alabama in all courts, state and federal, throughout the state. Today, I wanted to talk to you a little bit about what happens if your out-of-state company gets sued in the state of Alabama, whether it's an Alabama state court or one of our federal courts in the state of Alabama. What do you do? And I thought probably the best way to handle that would be through the use of a case study, a case that I recently handled. I'm going to go ahead and share my screen with you, and we can go ahead and get started with this. Defending your out-of-state company, a case study. First thing that you need to know in the event that you've been sued is it is important for you to act promptly. And the reason is you have a very short timeline within which to file something known as a responsive pleading to the complaint or lawsuit that's been filed against you. In Alabama, you are more than likely going to be sued in one of three different courts. You're either going to be sued in state district court, state circuit court, or one of our federal district courts that's located within the state of Alabama. And each one of those courts have a different time frame within which you must file a responsive pleading, or you may lose some very valuable rights. And in fact, you could even lose your case in the event that you don't file timely. You're in Alabama State District Court, you have a very short 14-day time period to file something. In federal district court, you have 21 days, and then in Alabama State Circuit Court, you have 30 days. I guess the good news is that in state district court, there's a jurisdictional limit of only $20,000. So if you're sued there, that's the maximum that they can recover in the event that you don't file something timely. More than likely, if it's a larger case, it will be filed in one of the other two venues. You may have noticed I keep saying responsive pleading. Other lawyers may talk about you need to file an answer within 30 days. And often that's the right thing to do in a state circuit court, or an answer within 21 days in federal district court, for example. But that's not always the best thing to do. In some cases, a strategic decision may make that not the preferred thing for you to do. And let's talk about our case. We were hired by an out-of-state company that had been sued in Alabama State Circuit Court. And so we looked at what the lawsuit was about. We read the complaint. We talked to our client. We looked at some underlying documents, and then we considered, was that a good venue for our client to defend its position in this particular lawsuit? We looked at the reputation of the county. We looked at the specific judge. And we're fortunate in Alabama, and particularly in this area, to have some very fine judges. And so often it's not a case of whether or not you have a competent judge. It's just whether that judge is the right fit for that case. In our case, we knew who the judge was because as soon as the lawsuit is filed, the plaintiff randomly draws an assigned judge to hear the case. So we knew as the defendant who that judge was, and we could consider that particular judge for our case. In our case, we determined that was not a good fit for our particular client. So at that point, we had some options, and one of our options was to remove the case from state circuit court to federal district court. Now, in order to do that, you have to file the right paperwork, the right legal pleadings. You've got to remove the entire case in the case file from state court to federal court. You have to file pay the right filing fee. You have to cite the right jurisdictional prerequisite and meet them. And in short, you've got to do everything right, and you've got to do it timely. And in order to do all those things, to effectively, you've got to hit all the right buttons. If you miss something, then it's going to be a defective removal and you're going to have a problem. So we did everything that we were supposed to do, and we effectively and legally removed the case from state court to federal court. And at that point, we came to our next decision, and that is, again, we were randomly assigned, in this case, a federal court magistrate judge. Now, federal court magistrate judge is a judge that is not one that's appointed for life. Instead, these are ones that have a specific tenure. And in order for them to have jurisdiction or power to hear the case, both parties must agree to have them exercise jurisdiction. So that was the next question that we had. Was this a good judge for our case? Again, this is part 2. And once again, many factors went into that decision. In our case, we determined that that would be a good judge for our case. In fact, an ideal judge for our case. We thought that this judge would be receptive to our legal arguments, was fair-minded, intelligent, and could understand the arguments that we were going to be making. So we consented to the exercise of jurisdiction for that magistrate court judge. We did so properly, we did so timely, and fortunately, the other side, the plaintiff and the plaintiff's attorneys, also agreed with us, and they consented to that magistrate court judge exercising jurisdiction, which meant that that's the judge for our case. In the meantime, things are going on. In the law, that's kind of what happens. There's a flurry of activity, and then sometimes in your case, there won't be anything that occurs for a period of even up to several months. But in this case, we had a flurry of activity. And the flurry of activity was that the plaintiff and the plaintiff's very fine attorneys believed that state court was a better court for them to have their case heard. And so they filed a motion to remand the case back from federal court to state court where it originated. Well, obviously, since we initially believed that state court was not an ideal venue for us, and we liked the venue in federal court, and we liked the federal court judge, that was something we were not going to consent to. And in fact, we had to fight that every step of the way. We filed a motion to oppose that. We filed our opposition briefs. We had to perform legal research to tie case law and precedent and statutory law and procedural law to the specific facts of our case. We had to look to contracts, and in our case, a franchise agreement, to look to personal jurisdiction issues that permeated throughout the case. We were fortunate, even though the plaintiff and their very good lawyers had very good arguments and made very good arguments, that the judge agreed with us, and the case remained in U.S. Federal District Court. We then went, and remember, we still haven't filed an answer in this case. We haven't filed something that's typically considered a responsive pleading. So we went to our ultimate strategy, which was to file a motion to dismiss the case. That doesn't often happen early in the stages of a lawsuit. Judges typically won't dismiss a case at least until the case goes on for a period of time and they can see that there's no merit to the case, and through motion for summary judgment or otherwise. But in our case, we felt like it was appropriate for a motion to dismiss, and so we filed that motion to dismiss. Now remember, this federal court judge has already granted our opposition, or basically denied the plaintiff's motion to remand the case back to state court. And now we're asking the federal court judge to dismiss the case in its entirety. Once again, we had to file our motion, our brief. We had to have legal research done to tie the facts to existing case law and other precedent, and the plaintiff's lawyers were doing the exact same thing. We both made the best arguments we could, and fortunately, the judge agreed with us. So not only did the judge deny the plaintiff's motion to remand, but the judge granted our motion to dismiss the case. A home run result for our client. The case was dismissed permanently in the state of Alabama. Now, what did all this mean? Well, you probably know that all this activity that I was discussing, the motions that were filed, the briefs that were required, the research, took time and effort on the part of the attorneys. And as such, our client felt a pinch because they did have to suffer legal fees. And ultimately, I counsel all my business clients and tell them that in the event you get sued, you're going to lose, because even if you win, you're going to end up having to pay some legal fees almost 100% of the time. And that was the case here. They had to pay some legal fees. They had to pay some expenses and filing fees and things of that nature. But in the long run, it saved them a ton of different expenses. How were they saved? To paraphrase Elizabeth Barrett Browning, let me count the ways. Full dismissal meant that the case never entered into even the discovery stage, the very early stage of a lawsuit in which both sides hear about the other side's case. There are no depositions that were taken. There are no court reporter fees that had to be paid. Lawyer fees to sit through the depositions, to prepare for the depositions, to analyze the depositions did not have to be paid. Our client did not have to get in an airplane and fly many states away to the state of Alabama to come to these depositions, disrupting their business. No paper discovery had to take place. There were no interrogatories, no requests for production of documents, no requests for admissions, no interrogatories. In short, it saved likely tens of thousands of dollars. In our case, it's not always going to be that expensive, but in our case, it saved tens of thousands of dollars by us winning the case that early. In addition, that's just through the discovery stage. In addition, generally a motion for summary judgment would be filed afterwards, which is a very substantive motion that ties together all the things we've talked about before: the briefs, the case precedent, the facts, other law, together with exhibits and the discovery that's taken place. And they can generally be very expensive as well. And of course, ultimately, there was no trial in Alabama. Our client was not required to travel to Alabama for purposes of the trial, to prepare for the trial, to sit through a trial, and of course, no exposure because the case had been dismissed. So we didn't have to run the risk of an adverse result in the state of Alabama. The moral of the story: act promptly if you are served with a lawsuit out of state. Make sure that you obtain competent legal counsel who understands that you've been sued and the timeline is ticking. Invest in good legal counsel to take aggressive actions where appropriate. If they can take aggressive actions early, it could save you a lot of money in the long run. And then finally, of course, please feel free to contact me in the event that you or your company is sued in the state of Alabama, or even if you have a company in Alabama and you're sued out of state. I will be more than happy to assist you in finding competent out-of-state legal counsel to help represent your interest. I hope you've enjoyed this, and if it ever comes to pass, it is helpful to you. Thanks, and you have a great day. Bye-bye.